immediately willing to join us and explain that argument, as he will do in just a minute. Douglas Farrow is professor of theology and Christian thought at McGill University in Montreal, where he works in theology, ethics, church state, and social political issues. He is author of a number of books, most recently, the provocatively entitled Nation of Bastards, Essays on the End of Marriage. Professor Douglas Farrow.
Thank you, Phil. It's a pleasure to join you. The book you just mentioned is actually from 2007. I will make reference to it in passing, along with some other things that may be useful to the audience here. I want to begin with the question you pose, who owns your children? That may seem a very odd question. If they are your children, well, surely you do. It may also seem a rather overwrought question. People don't ordinarily raise an eyebrow at the phrase, my children or your children. This kind of thinking is part and parcel of ordinary life, but not so fast. It was part and parcel of ordinary life until a few years ago, to suppose that your children were not only yours, but that they were boys or girls, that they had a sex, and that having a sex was a good thing. That you or the doctor who delivered your child may have imposed a sex on your child wasn't commonly said, nor that your child might do well to choose, if not a new sex, then a new gender. We live, as Eomer said to Aragorn in The Lord of the Rings, in a world all grown strange. This new and strange world is offered to us as if it were the golden wood, Lothlorien. And now we are being accused of beating a hasty retreat from that golden wood into the redoubts of a backward and oppressive land, the land, I suppose, of rednecks and traditionalists generally. Go on then, we're told, beat your retreat. But don't suppose you'll be taking your children with you, for they are not your children. They are everyone's children. They are, if it comes to it, the state's children. And the state will protect them from you and lead them forth into the wonders of its Lothlorien. It will not abandon them to your abuse or leave them as hapless objects in which you may replicate your own, well, frankly, dehumanizing ideas and ideologies. You may feed their bodies if you like, but the state will see that their souls are fed. The state has schools for that, and all children must attend those schools. The organizers of the conference that was intended for June, Elizabeth Bartolet and James Dwyers, are among those who say such things. For nearly 2 decades now, they have been trying to make the case, to use Professor Dwyer's words, that parental rights must be challenged in their entirety. Parental and family rights must give way to individual rights and the rights of the state. Why? Because they conflict with, he says, principles deeply embedded in our law and morality regarding personal autonomy and self-determination, end quote. Well, actually, let's quote him a little bit further. The incongruity, he says, between parents' rights and established principles regarding the nature and inherent limitations of individual rights compels us to seek other moral or legal principles to support and legitimize this anomalous set of rights, these parental rights. parental rights, he is arguing, must be reduced to parental privileges conferred by the state and maintained or withdrawn at the state's pleasure. Maintained for those who cooperate in the kind of formation the state deems appropriate, withdrawn from those who abuse children by giving them some contrary formation, or rather indoctrination. For parental rights represent the domination, he says, of the strong over the weak, and the state's business is to prevent that. Now let's set aside here the question as to who is abusing whom, who is indoctrinating whom, who is the ideologue, and who is dominating whom. Mr. Dwyer thinks that parental rights, I use his words again, ultimately rest on nothing more than the ability of a politically more powerful class of persons to enshrine in the law their domination of a politically less powerful class, end quote. Last I checked, I think I agree with Professor George here, that description seemed to fit rather better law professors from Harvard or even William and Mary, to say nothing of Princeton or McGill, than it fit ordinary parents. It is the former, in alliance with large corporations, including those from which they come, the modern universities, who are adept at weaponizing the law, not the latter. Let us inquire then into the ideas themselves, rather than to stay at this sort of polemical level that I find as I read these articles of theirs, and into the moral and legal principles with which they work. And here, since we have only 20 minutes or so, let's focus on just three key elements in the debate: individual autonomy, the institution of marriage, and the role of religion. And let's look at these briefly in their relation to one another. In chapter 7 of my recent book, Theological Negotiations, I have traced out the evolution of the idea of autonomy over the last millennium, approaching it as a theologian rather than a legal scholar, which I am not. I was not trying to replace Schneeven's book on the subject or other such works, whether philosophical or legal. One can hardly do that in 40-odd pages. But to show how our recent notion of autonomy has abandoned the Enlightenment without abandoning the Enlightenment's philosophical roots in nominalism. And I was trying to show further that nominalism contained the seeds of its own destruction, precisely because it refused to wrestle with the individual as anything other than an individual. It would not do this respecting the divine persons, which in a millennium ago was a major part of the conversation, nor would it do so as regards human persons. It therefore could not conceive of autonomy in the last analysis as anything more than raw, undisciplined exercises of the will, acting independently even of reason, and asserting itself even against the most obvious givens of human existence, such as the body. It has taken a full millennium for it to come to this, but it has. Autonomy now means, in a borrowing of biblical language, indeed, in a profaning, one might well say, of the divine name, as given in the Jewish and Christian scriptures, I am who I am. And the first commandment in the new reality is that you must recognize me as whoever, whatever I say I am. Now, this kind of radical individualism, this notion of autonomy that trumps reason and the evidence of the body, is being used today to reshape the sphere of the body, that is, the public sphere, and the laws that govern it. The central locus of this reshaping is family law, which should surprise no one. For the family is the most stubborn obstacle standing in the way of this sola autonomia, by autonomy alone, revolution. The putatively autonomous individual, I speak of embodied individuals, of humans, not of angels, arise, after all, from the sexual union of a man and a woman. And the institutionalizing of the relation between a man and a woman in the form of marriage, understood as a context for bearing and raising children, is ground zero for the passing of human culture from one generation to another. So, if all that seemed too philosophical for some of you, don't worry. We come to things you understand more readily, perhaps, than what I've been saying. When you want to change a culture, you must change marriage. Marx and Engels knew that nearly a century and a half ago. The Soviets tried it briefly, some 90 years ago. Keen observers at the time, such as Sigrid Undset and G.K. Chesterton and Christopher Dawson, extrapolated the trajectory that this would take in the West with remarkable accuracy. And now we have arrived at a key point in that trajectory, a point in which the concerns of this conference are fully implicated. That point is called same-sex marriage. I'm not going to try to explain here, since we haven't the time and it's not the direct topic of the conference, how same-sex marriage came to be, either in my country or in yours. On that topic, I will say only this. In your country, as I had occasion one evening over dinner to point out to one of your Supreme Court justices, what the Universal Declaration of Human Rights in Article 16 defined as an individual right, namely, to quote, that men and women of full age without any limitation due to race, nationality, or religion have the right to marry and to found a family, end quote. That somehow became, through sloppy language and sloppy reasoning, a couple's right. That is, the right of any two people to demand a marriage license. Thus, in this curious slippage from the concrete individual who already universally enjoyed the right to seek marriage, if not always the power, of course, to find it, from the slippage from that concrete individual to this essentially bodiless couple, this abstract union of two persons, as we already called it up here in Canadian law, the obstacle of marriage was overcome. The obstacle of the body was overcome. Autonomy would no longer have to take the body into account. Marriage would no longer have to take procreation into account. Founding a family could mean anything one wished it to. And family law could be changed in whole and in part to eliminate all further obstacles and impediments to the changes desired in some circles. Now, perhaps no one knows more about marriage law, historically speaking, than Professor Whitty at Emory Law School. His conclusion in the book called From Sacrament to Contract is worth repeating because it does, as you will see in a moment, bear directly on the concern about homeschooling. The elementary deconstructions and dismissals of a millennium-long tradition of marriage and family law and life seem altogether too glib to be taken so seriously, writes Professor Whitty. I continue. Yet the legal revolution marches on, and the massive social, psychological, and spiritual costs continue to mount up. The wild oats sown in the course of the American sexual revolution have brought forth such a great such a great forest of tangled structural, moral, and intellectual thorns that we seem almost powerless to cut it down. We seem to be living out the grim prophecy that Friedrich Nietzsche offered a century ago, that in the course of the 20th century, the family will be slowly ground into a random collection of individuals, those were Nietzsche's words, haphazardly bound together in the common pursuit of selfish interests. And, adds Whitty, in the common rejection of the structures and strictures of family, church, state, and civil society, end quote. As I added, however, myself, when quoting this passage in Nation of Bastards, there's a further dimension to the problem. It was pointed out by another law professor, the late Ted DeCoste, in an essay called Courting Leviathan. DeCoste was convinced, and rightly, I think, that statism was the great threat that accompanied this radical individualism. For by means of the false distinction between religious and civil marriage, the state has taken possession of marriage in a paternalistic manner. It has thus, as DeCoste says, committed itself to a redemptive politics, that is, by means and medium both, that makes jest of limited government. And I quote here Professor DeCoste a little further. Redemptive politics, he says, is a politics of conviction. The redemptive state is a state convinced that its proper purpose is to improve its subjects by imprinting on them, on their projects and character, the values that the state has made its own and declared superior. Such a state is not merely a custodian and guardian of the people's proper values, though it is clearly both. The redemptive state rather conceives of itself as the personification of those values, and with that, of the lives of the governed properly lived, which is to say, state and people are in theory one, and so they do in fact become, to the extent that the state succeeds in disarming the people of values that contradict or diminish its values. But this transformation of the state into a person and persons into expressions of the state comes at the cost, in equal measure, of moral arrogance by the state and of the moral disablement of the people, end quote from DeCoste. But that, it seems to me, is just what Bartolet and Dwyer's and those of their persuasion have been calling for. It seems to me just what they actually mean to achieve. The family, which the Universal Declaration identified as, quote, the natural and fundamental group unit of society, entitled as such to protection by society and the state, Article 16, is no longer to be such. It's no longer to be the fundamental unit. It's to be an extension of the state, operating at the state's behest, lacking all primordial or pre-political rights. As I never tire of saying, and some of you will have heard me say this before, we are all wards of the state now that marriage has been detached from procreation and become merely a legal fiction. And those who position themselves as experts, whether medical experts or moral experts, will tell the state what it ought to do with families. Now, lest you suppose I'm making this up and cherry picking a few quotations from people who have some shared concerns with the ones I'm articulating here. Let me quote from Joseph Raz, who in his famous work, The Morality of Freedom, prophesied this. More recent changes, he says, this is 2003, are uncertain and incomplete. Some tendencies, that is to, for example, to communal families or open marriages, may wither away. Others, for example, homosexual families, may be here to stay. It's too early to have a clear view of the consequences of these developments. But one thing can be said with certainty. They will not be confined to adding new options to the familiar heterosexual monogamous family. They will change the character of that family. If these changes take root in our culture, then the familiar marriage relations will disappear. They'll not disappear suddenly. Rather, they will be transformed into a somewhat different social form, which responds to the fact that it is one of several forms of bonding, and that bonding itself is much more easily and commonly dissoluble. All these factors are already working their way into the constitutive conventions which determine what is appropriate and expected within a conventional marriage and transforming its significance, end quote. So now at last to the point that really matters to you. Marriage, since, I'm sorry that it took so long to get around to this, but I needed to clarify the background. Marriage, since it's no longer procreative, since it's no longer based on intergenerational interests and functions, but only on raw autonomy and or on shared projects that any two or perhaps soon more people put together. Because it's no longer procreative and intergenerational, it's no longer educative either. There's no longer any bulwark, either morally or constitutionally, that guarantees parental educational rights. Recall that statement of Dwyer's. It's not just educational rights, it's parental rights in their entirety, he says, which must be revisited, rethought, and in many serious respects, removed. There are only residual instincts, residual habits of law and policy, the erosion of which, in the long march through the institutions, in the universities, I must say that's march has not gone much further to go. That is now the goal. What you have to do is remove those residual patterns of life and their expressions at law, so as to clear the way for whatever is coming next. And hence such conferences as the conference that was planned for June. So, in other words, our situation, I think, is very, very serious. We have to see these proposals in their larger context. One does not have to examine the last millennium of developments in the understanding of autonomy in order to get the main drift of this, however. The family is no longer viewed as the primary context for the nurturing and educating of children. Well, if you ask me, all right, that's pretty negative. We have only had, in the States, you've only had same-sex marriage very, very recently. The other shoe or shoes has not fully begun to drop. But it sounds very dire. What's the hope? What's the sign of hope that you can offer? Well, I'll say this. I don't think the right hope is to downplay the religious connections. To say, well, look, religion has been privatized. Let's see if we can do this without any recognition of the theological and religious dimensions to this. The flourishing of the human person depends on givens like the body itself, givens like the gift of life. If we try to do our thinking collectively without any reference to givens and to givers, and without any reference to the great giver, who is God, our creator, our whole sense of life as being a gift and of these givens that make for the public sphere, the givens that we all recognize, bodies and relations between bodies, physical spaces, which we're losing with all this Zoom business. If we set all that aside, what makes us think that we will have any kind of foundation on which to work out these problems concerned with human flourishing? So my advice would be, don't be afraid of the theology. Don't be afraid of the philosophy. Don't be afraid of the religious dimensions. Don't be afraid of identifying parents as givers of life to their children. Who owns the children? Ultimately, the Creator owns the children. But who co-creates with the Creator? Parents do. And they should not be bashful, they should not be shy, and they should not be afraid to engage in the public conversation, drawing in the resources that have been handed down to them through the generations.
Farrow, thank you very much. I hope you can now hear me.
Yes.
Good. We're having no more than the predictable number of snafus with the technology. I'd just like to say, by the way, in the interest of honesty and advertising, that when we chose the title for this conference, Who Owns Your Children, we were being deliberately provocative. We were not suggesting that parents are the owners of the children. St. Paul would suggest otherwise. I'd like to just take a moment and ask you a question. If the Universal Declaration of Human Rights recognizes parents, the family, as the primary building block of society, think of it as sort of the atom from which societies are built, then we're now engaged in atom smashing with predictably dangerous results. From the other perspective, you mentioned what you call the redemptive state. It seems to me that if you are familiar with the political history of the United States, it's a country founded on the assumption that the people are the government. That's profoundly at odds with the notion that the government exists to perfect the people. It's absolutely standing it on its head. And therefore, wouldn't it behoove us to go back to the language of the founders and recapture the understanding of limited government?
Well, it certainly would, and I am certainly in favor of that. Education, of course, shapes people. It is formation, and so that's why this if family law is the center of the vortex of change in our society, education law is very near that center, because if you can achieve a shift of onus from the families and a shift of corresponding rights and responsibilities from the family to the state, then the state can form the citizens in a manner that suits the state. And then it could say, well, yes, we, the people in the state are at one. The majority culture thinks thus and so. I've found in reading this literature, of course, that game is played the way the Bolsheviks played it. We pretend to be the majority when we're actually the minority. And then we persuade people that they must join us. And so we fulfill our own prophecy of becoming the big party, not the little party. And state education, state schools can function to further and hasten that process. And people who are working at the intersections of family law and education law understand that and are using it to good advantage. And I think at the moment, there's still a sense of, yes, we, the people, have a right to resist this. But if you win the next generation so that they don't want to resist it, you've won, you see. And that's why
Absolutely.
both private schools, as Professor George was saying, and homeschools, as he was saying, are very important in providing a different kind of formation. Personally, I think at the tertiary level, we need more institutions like your own, because the long march through the institutions at the tertiary level is almost complete, as I've said.
Yes. And this would underline your advice that those who are interested in homeschooling and maintaining parental rights should not be afraid to engage in the philosophical, theological, and political battle.
Yes, and I think we can draw on a better knowledge of history than I'm afraid many of our contemporaries have, to say that these big issues were always argued in all these dimensions. And this idea that we must argue them with one hand tied behind our backs, I think we must definitely resist.
Thank you very much, Douglas Farrow, for your contribution. Our next event in this